We are streaming just now.
Thank you. Okay, good morning, everyone. Welcome back. This is day 5 of the inquiry into the Section 36 application for the Sanctuary wind farm. Today's the last day of inquiry session 1, where we are hearing evidence on aviation radar and systems. Today we will hear the evidence of Miss Kilpatrick from Glasgow Prestwick Airport. So this session is being live streamed on the DPA webcast site, as is the whole inquiry, and the recording of today should be available there after the weekend. For anyone joining us for the first time, my name is Christopher Warren. I'm a Scottish Government reporter and I've been appointed by Scottish ministers to conduct this inquiry. Can you all hear me clearly this morning?
Yes.
Good.
Yes, thank you, sir.
Thank you.
Okay, so in terms of, just before we move into the evidence, in terms of the programme for the rest of the inquiry, the next session, so that's inquiry session 2, will begin a week on Monday, so that's the 18th of October at 10 AM, with subsequent days at 9:30 AM, as we've done this week, and this will be focused on the proposed developments, landscape and visual effects. Don't think I need to say anything more about that now. That was covered on Monday this week. Are there any matters arising or any questions since we concluded yesterday afternoon?
Sir, if I may, on
Mr.
that.
Brown.
Yes, with regard to the table of the PD figures, which was discussed at close of business yesterday.
Yes.
Sorry, I'm actually just been handed a note. Yes, the figures were not received overnight, but Mr. Thompson has spoken to Nats this morning and I've just been passed a note to say that they will provide them this morning.
Excellent, thank you. That's helpful. So as I said yesterday, if that could be circulated to parties by email and sent to Jane Anderson, the case officer, that would be very helpful. Thank you.
Right. Of course, sir. We'll organise that.
Is there anything else, Mr. Brown?
No, that's all, sir.
Okay, thank you. Mr. Hardy? No? Okay, lovely. Okay, so when you're ready, Mr. Brown, you can call your witness. Thank you.
Thank you, sir. My next witness is Miss Zoe Kilpatrick, who I see is on screen. Can you hear her all right? Hear us all right?
Indeed, yeah.
Thank you. Now, what I'd like to do is I'd like to start by asking you to read your recognition, and after you've read it, I'll have some follow-up questions for you. But when you're ready, could you please begin to read your recognition?
Yep. Personal details. My name is Zoe Kilpatrick. My address is care of Glasgow Prestwick Airport, Prestwick, Ayrshire, KA9 2PL. I joined Glasgow Prestwick Airport, the airport, in 2018 as its commercial director. For the past 3 years, I've been responsible for all commercial activities at the airport, working at executive level, reporting to the CEO. Background. The airport's business model has changed over the years, from serving as a military airport to developing as a major freight hub, operating passenger services and fixed-based operations, FBO, and providing aircraft maintenance. The airport has the busiest by movement FBO in Scotland and is home to the busiest by movement search and rescue base in the UK. It is also home to a Royal Navy forward operated base, HMS Gannet. The airport also routinely hosts multinational military training exercises. In recent years, it has played a major role in supporting key events such as G7 and POTUS visits. In October and November this year, the airport will play an important role in support of COP26. The airport has also just announced it has secured a launch partner for its spaceport development, with an ambition to become Europe's premier launch location. Although the airport is committed to continuing to development its traditional flight movement base, it also sees significant opportunities in the drone and AUV market, which is currently emerging. Policy framework. The airport has many regulatory obligations, Those which are of particular relevance are CAP 670, which is document CD 13.1, CAP 760, which is document CD 19.11, and CAP 764, which is document CD 13.2. The CAA mandate within these publications says that the responsibility for the provision of safe services and safe systems lies with the ATS provider, which in this case is the airport. The regulation of airspace and policy in respect of the mitigation of adverse effects caused by wind turbines on the airspace is a reserved matter. The UK government's position is that the cost of mitigation should be borne by the developer of the wind farm. Document reference CD 19.93. The CAA follows this principle. The airport is seeking an urgent discussion with the UK government via the Department for Transport relating to the issues arising from wind farms in the environment of airports. The airport's support for net zero. The airport is committed to supporting the development of renewable energy and the corresponding reduction in carbon emissions. However, wind farms cause considerable adverse impacts upon the airspace and radar performance. Wind farm developments can therefore pose a risk to aviation safety, which is the airport's paramount concern. In spite of those issues, the airport has worked extremely hard with wind farm developers over the last 10 years to find solutions which have allowed the release of 500 megawatts of electricity. It is also currently actively involved with 12 other developers in connection with the potential release of up to 1 gigawatt of renewable energy. Mitigation required as a result of the proposal. The airport's first and foremost concern is one of safety. Apart from the fact that the airport has a regulatory obligation to fulfil, which is designed to ensure safety of aircraft, it has a duty to all aircraft which uses its airspace to ensure that they do so safely. One of the consequences of the increasing presence of wind farms in the vicinity of the airport is that more and more mitigation is required to ensure that the adverse effects of wind turbines are minimised. If the airport did not mitigate the adverse effects of turbines on its surveillance systems, it would have to accept that more and more of its airspace is not safe to use. The airport has committed a significant amount of time and energy over the past 10 years to explore and test new technologies that have the potential to mitigate some of the impacts of wind farms. Although some of the adverse effects can be mitigated, there are residual impacts which remain. The necessity for mitigation has clearly been caused by the developers who wish to erect wind farms. When making that point, it has to be remembered that A, the airport has no choice about where the wind farms are located, and B, the costs and risks associated with mitigating the development are in effect imposed upon it. They are not costs and risks which the airport has decided to accept as part of its business. As a commercial organisation, the airport cannot be expected to accept the imposition of costs and risks which will endure for the lifetime of the development without being compensated for that happening. On the matter of costs, there are a few points which should be made clear. First, the airport is not seeking to recover the costs which it would ordinarily incur in providing and maintaining its communication, navigation and surveillance DNS infrastructure. The airport fully accepts that it has those obligations under the relevant regulations. The costs which have to be addressed are the additional costs which the airport will incur in providing and maintaining DNS due to the fact that it is operating in a wind farm environment. Second, the airport's exposure is not confined to cost. There is also the risk exposure which it faces in maintaining the required mitigation. That exposure should not be left out of account. Third, costs are not limited to the costs which the airport will incur to third parties. They also include the value of time which the airport's employees must commit to ensure that mitigation is provided. The airport not only faces known costs, but risks but given the long-term nature of this project, it is also exposed to the costs and risks that are currently unknown. A summary of these costs and risks can be found in the table of costs and risks, which is document reference CD 19.76. The aggregative impact of wind farms for the airport. This inquiry and the earlier Clauchrie inquiry have made the question of mitigation of wind farm proposals very topical. Although other airports in Scotland have wind farms operating in the vicinity in which they provide ACS, none of them appear to be facing the issue on the same scale as the airport. Further, it should be added that the fact that the size of the turbines and the intensity of the wind farm development takes the airport into unknown territory, and the potential cost and risks which that may bring is of particular concern. Wind farm mitigation agreement. Wind farm mitigation agreement, WMA, mitigate the cost and risk an airport or ANSP will face from a development, and they provide certainty to developers to allow them to conduct their operations. Under the earlier versions of the airport's WMA, it received sums from developers who erected wind farms within the vicinity of the airport. However, when considering that figure, it should be remembered that those payments were one-off contributions towards all of the mitigation, which will be required for the lifetime of those developments. In each case, a minimum of 25 years. The airport does not have the ability to go back to those developers to seek any additional payments. The airport accepts that the money received from developers was used in the installation of the WFRMS. However, Terma, which is part of the system, does not have the same performance characteristics as the existing Marconi S511 primary radar PSR. To achieve the same level of performance will require further investment. To increase the transmitter power of Terma to improve the range performance, to provide a second channel for Terma, the existing Marconi S511 PSR has such a channel. In a primary feed from another ANSP to supplement Terma radar to attain the same range of primary coverage as the existing Marconi S511 PSR, and in consultancy services, safety assurance works, and airport time to deliver all of the above. Further, when considering the question of costs which the airport has incurred, account has to be taken for the time which the airport has had to invest generally in the installation of the WFRMS and mitigating the impacts of the particular wind farm development for which those payments were made. The amount of time which the airport has had to invest in those tasks should not be underestimated. The airport is currently on its third iteration of its WMA. Its style of WMA has evolved over the years as the airport has reassessed the terms of the agreement in light of the fact that it has installed WFRMS. The changes to the agreement have been made to maintain a position of reasonable charges. And all of the changes have been designed to improve the terms of the agreement in favour of the developer. Engagement with the applicant. The applicant is of the view that it should not have to pay anything to mitigate the adverse effects its development will have upon the airport beyond some initial optimisation stages. The airport remains willing to have discussions with the applicant about the terms of a mitigation agreement, but before it can do so, it requires the applicant to enter a non-disclosure agreement, NDA. NDAs are a normal aspect of business for matters such as this. If the airport was to have a discussion with the applicant without an NDA being in place, there is the risk that the airport would be in breach of the obligations of confidentiality which it has undertaken to other developers. The airport sought to address the applicant's concerns in respect of entering an NDA. It accepted the applicant's proposed terms for the NDA. When a final version was put to the applicant for signing, it refused to do so. The airport tried to make the applicant aware that the new terms of the agreement were materially different to previous agreements it's seen. However, it would still not engage in the process to allow it to have sight of the new terms. See document references CD 19.8.87, CD 19.88 and CD 19.89. The airport is keen to have a conversation with the applicant regarding mitigation. Apart from anything else, it is puzzled by the approach the applicant is taking to the need for mitigation, particularly on an ongoing basis. It is known in the context of this inquiry that NATS, just like the airport, objected to the proposal. That objection has been withdrawn on the basis that an agreement has been reached. Document reference CD 6.11. The airport does therefore not understand the applicant's inconsistent approach to this topic. Conclusion. The proposed development without mitigation will have an adverse impact on the airspace around the airport. It is not appropriate that the airport should be burdened with both costs and risks associated with ameliorating that impact in order to safeguard the airspace in which the airport provides ACCS. It is clear from document CD 19.50 that the airport is looking at a very significant number of wind farms being developed within its ACS environment. The costs and risks associated with providing mitigation for all of those developments for their operational lifetimes will be a colossal burden for the airport. The point has already been made that that burden, which does not relate to its operations, will be imposed upon it. Sanka 2 will make a contribution to that burden. Mitigation, both now and in the future, is required as a direct result of the proposed development. The burden of that mitigation should be borne by the applicant.
Thank you very much, Ms. Kilpatrick. Now, just to be clear about this, can I confirm with you that you also prepared a report for the inquiry?
Yes, I did.
Yes, which is CD 1902. Now, as I said, I've got some further questions for you arising from your recognition, Ms. Kilpatrick, and some supplementaries regarding issues which have arisen during the inquiry. So, first of all, if I can take you back to paragraph 8 of your recognition.
Yep.
And this is where you cover the topic of the airport support for net zero.
Mm-hmm.
Can I ask you what, if anything, you would like to add to that paragraph?
Yeah, well, I'd like to make it clear that we're certainly not trying to impede the development of renewable energy. The airport has and continues to work hard to find solutions that allow the interest of both parties to coexist without one impeding on the other. And secondly, I'd say it's not about profit. Wind turbines in radar line of sight create adverse impacts on the airspace, and they impose cost and risk to the airport as it meets its regulatory obligations to ensure that the airspace remains safe at all times. And safety is paramount, and that remains the case for the lifetime of the wind farms. And I think it's important to note that we're behaving in the same way as other airports and ANSPs in our need for a mitigation agreement.
All right, thank you very much. Now, can I take you to paragraph 15 of your recognition?
Yeah.
And this is where you refer to the table of costs and risks.
Yep.
Which is CD 1976. Can I ask you, what role did you have in the preparation of that table?
Well, I was involved in the discussions with the technical expert who helped inform the contents of that.
And just for the clarity on that, who were the technical experts?
Mr. Thompson, Mr. Fido, and Mr. Kirkland.
Okay, thank you. Now, did you hear my cross-examination of Mr. Parkinson on Monday regarding the table of costs and risks?
I did, yes.
And having heard Mr. Parkinson's responses, when I put the table of costs and risks to him, to what extent have you changed your views on the costs and risks shown in the table?
I haven't changed my views at all.
Thank you. Now, if I can take you to paragraph 18 of your recognition, where you cover the topic of one-farm mitigation agreements, could I ask you to explain the role one-farm mitigation agreements play?
Well, I think first and foremost, they are enablers. Government policy understandably has a drive towards renewable energy, and the air modernisation strategy states that airspace is a national asset that's to be preserved and enhanced. Turbines can cause an adverse impact on that airspace, and we have a regulatory obligation to ensure it's safe. So clearly there's a tension there, not helped by the fact there's no regulation to say how this should be resolved. Mitigation is not provided by government. Now, the only direction we have is from the DfT, and their position has remained consistent since it made its position clear, and that is that the costs of mitigation should be borne by the developer who benefits commercially from the activities of the wind farm. Now, in that situation that we find ourselves in, the sectors have dealt with this through mitigation agreements, where there is essentially a settlement of cost and risk, which is discussed and agreed between the parties, and it gives both parties, to some extent, certainty. Certainty for the developer in terms of the costs, and a degree of certainty for the airport or ANSP that it will have the ability to continue to invest in mitigation technology to maintain safe airspace in that wind farm environment for the duration of the development. And these agreements aren't freely available. They will always be bound, in my experience, by confidentiality, and we're no different in that respect. The airport has entered into a number of mitigation agreements which are bound by confidentiality, and on that basis we're not able to share the terms of the agreement at the public inquiry.
Thank you. Now, in paragraph 22, you referred, of your recognition, you referred to the fact that the airport is currently on its third iteration of its one-farm mitigation agreement. Could you explain how the evolution of the one-farm mitigation agreements have developed, please?
Well, initially they were capital contributions towards a surveillance system. We're continually assessing how we structure charges in light of better understanding of the environment and changes in the environment, on the basis that we have made an initial investment in system. We felt it appropriate to move to an annual payment rather than an upfront in full contribution, on the basis that the costs occur on a regular basis. But we've made other changes as well. I note that Mr. R. Thompson concerns about the increasing capacity that turbines have, and we've addressed that within the mitigation, within the latest version of the mitigation agreement.
Thank you very much. Now, I'd like to take you to your report, and I'm sorry, sir, I referred to this as CD 1902 last time round, and it's actually CD 19-03, so my apologies for that.
Thank you. That's fine. I've got Mr. Brown. There's a lot of beeping in the background, which I think is somebody possibly joining and then leaving, or muting and unmuting. It seems to have stopped. So maybe just saying that has done the trick. But if it interrupts the sort of flow of proceedings, just let me know if it's distracting you. Okay. Thank you.
Thank you, sir. Now, what I'd like to do, Ms. Kilpatrick, is take you to paragraph 19 of your report.
Yep.
And you say there that there are initial costs, things that come right at the start of the process, and costs that continue throughout the life cycle of the wind farm. And what I'd like to do is ask you if you can explain the initial costs and the things that come right at the start of the process.
Yeah, I think it would be useful to refer to the airport safeguarding process to just illustrate these steps. That's document reference CD 19.25.
All right, thank you. And can I ask you, how familiar are you with this process?
Well, this is the airport standard safeguarding assessment process that's approved by our board.
All right, and at what stage are you involved in this process?
At step 15.
So that's on engagement with the developer.
Yep.
And so far as Mr. Thompson is concerned, where is he involved?
He's involved right from the very start of the process, from step 1.
Thank you. So you'd asked to be taken to this in connection with costs.
Mm-hmm.
And I suspect that the easiest way to deal with that is if you just talk us through what's happening from the stage you become involved at step 15.
Yep. Step 16 is conduct the baseline PD flight trial and radar data analysis. That step is coordinated by Mr. Thompson. That involves some costs which the developer pays for. Next stage is to agree the turbine mitigation agreement. Step 18 is to conduct the Terma radar modelling assessment. That's also coordinated by Mr. Thompson and incurs costs, which again are funded by the developer. On to step 19, which sees the results of the overall PD assessment. If the assessment is deemed adequate from a safety perspective, and Mr. Thompson talked about those requirements, then there are a few more steps, and the radar objection is removed, planning consent achieved, and then down to step 24, the turbines are constructed and the blades fitted, which will be some time after that. Step 25, so this is post-construction, just to be clear that the costs that we've talked about up until now were pre-construction. Step 25 sees the radar optimised in the airspace above the visible turbines. There is a cost involved in that, but that's covered by the mitigation agreement. And then step 26, undertake confirmatory flight trial over the turbines. That's the radar optimisation. Again, there are costs incurred in that stage. They are covered by the mitigation agreement. And the final step is the ongoing preservation and effectiveness of the wind farm mitigation system through the life of the wind farm. Again, cost and risk associated with that, which form part of the mitigation agreement.
Yes, and on these costs which form part of the mitigation agreement, who bears those costs?
That's the airport. That's part of the charge for the mitigation agreement.
So just to clarify that point with you, when we get to steps 25, 26 and 27, those are costs borne by the airport.
Yes.
And to what extent are those costs at steps 25, 26 and 27 shared with the developer?
Well, they're not.
And why is that?
Well, because steps 25 and 26 are well, they're not funded by the developer directly. They form part of the mitigation agreement, so we would never correspond with them on the cost for those for those tests. Step 27 is the ongoing costs of maintaining safe airspace and maintaining an appropriate level of mitigation for the life of the development. And we obviously talked to the developer about the costs that we assess as being reasonable to transfer that risk, but a lot of those costs are unknown and hard to quantify.
Thank you very much. Now, I'd like to ask you to look at the condition which has been proposed by the applicant. You just let me know when you have that.
Yeah, I have that.
And we see here that there are four parts to the condition, paras 1, 2, 3, and 4. Now, so far as 1 is concerned, procuring Terma AS or its duly appointed representative in the United Kingdom to undertake a Terma radar modelling assessment to determine the Terma probability of detection reduction factor in connection with the development, and providing the results of such modelling to the airport operator, the developer and the Scottish ministers. Now, looking at the flow chart which we have looked at, can you point us to the steps which that condition would cover?
Yeah, that would cover step 16, step 18 and step 19.
Right, thank you. And looking at the second paragraph in the proposed condition, optimising the airport operator's operational thermoscanter 4002 primary surveillance radar to accommodate the development. What step is that in the flowchart?
Step 25.
And the third, validating any optimisation of the operational thermoscanter 4002 primary surveillance radar undertaken in respect of the development by way of flight trial over the development, if such validation is reasonably required. What step is that?
Step 26.
Okay. Now, you'll be aware of the discussion which has taken place before the inquiry about costs which were provided by Mr. Thompson to Mr. Parkinson at some stage during their discussions, and a figure of £60,000 has been referred to in that context. What costs were being referred to in that conversation, in that figure of £60,000?
Well, it would be all the pre-construction costs that the developer would bear.
Yeah. And why do you say that?
Because we wouldn't talk to a developer about post-construction costs.
All right. And in terms of post-construction costs, which are steps 25 and 26, what sort of costs are we talking about there?
I think that somewhere between £40,000 and £50,000.
Thank you. Now, is there anything else you would like to draw to the attention of the inquiry, Ms. Kilpatrick?
No, I don't think so.
Thank you very much.
Mr. Brown, is that your evidence in chief?
That is evidence in chief.
Okay.
Thank you, sir.
Thank you, Mr. Brown. Thank you, Ms. Kilpatrick. Mr. Hardy, before we commence cross-examination, I'm assuming there might be a few documents that you would like us to refer to. Would it be worth listing those if that's the case now, and we may take a short break to
Yeah.
put those in front of us?
Yes. I mean, I'll preface this by saying I'm not sure, given where we've got to, really, the relevance of Ms. Kilpatrick's evidence. I'm going to be short, but I can tell you that it's going to be APP 02005, APP 02009. That's a letter written from CMS. APP 02010, that's a response from Denton's. Then the accounts, so far as we need to go to them, that's 002, 011, 012, 013. But the way I propose to deal with that is really to go through the transcript or pick out the key parts from the transcript of the cross-examination that was undertaken at Clauchrie, because that seems to be an efficient way of getting to some fairly simple financial matters. APP 02014, which is the article from the newspaper. And then, of course, the GPA inquiry statement, Kilpatrick's report, and her precognition.
Thank you, Mr. Hardy. I propose, just whilst we gather those documents, if we have a short break of, well, let's say 10 minutes, just to make sure we have got them all in front of us.
Yes,
So
thank you.
we'll resume at 10:15. Okay, thank you.
Thank you, sir.
Okay, how are we doing? Miss Kilpatrick, are you ready?
Yep.
Yeah. Okay, thank you, Mr. Hardy. Over to you.
Very much, Miss Kilpatrick. Just a few preliminary matters. What qualifications do you have? What are your professional qualifications, if any?
Well, I have a degree,
Okay, if you could just tell us what, so a degree in.
business and management.
Okay. And any other professional qualifications?
Nope.
Thank you. So not, and I think it's common ground, no, you're not professing planning expertise
Nope.
or legal expertise.
Nope.
Thank you. Therefore, you're not professing to give expert evidence on how cost and risk interacts with the planning system, or put another way, you're not really in a position, are you, to help the reporter about whether what you're asking for would be a lawful condition?
Well, we obviously seek legal advice on that, as we did with Clauchrie, and both of our legal advisors and senior counsel believe that what we are asking for is lawful. And as you say, I'm not a lawyer and I'm not a planner, and those things will be addressed in submission.
Yeah. And your senior counsel is who? You're talking about Mr. Brown?
No.
Right. So who, you've got lawyers behind the scenes. You're talking about Denton's?
Well, we work with both Denton's and Pinson.
So Denton's and Pinson's, right? And then your senior counsel, who's that?
Mr. Finlay.
That's James Finlay, is it? Okay. Obviously, he's not here. Mr. Brown is presenting the case on your behalf. Good. All right. I was interested in, do you have a planning? Some airports have a planner.
No, we don't have an in-house planner, no.
Okay. You make some points about what's devolved and what's not, which I'm afraid aren't right. Planning, of course, is a devolved matter, isn't it?
Yes.
Thank you. And under the Electricity Act, Section 36, there's administrative devolution of that too, isn't there?
As far as I'm aware, I'm not a planning expert, but I do believe that's correct.
Well, if your legal advisors told you that.
Well, yes, I believe that, yeah.
Okay. Come back to that. Now, have you been listening to the evidence this week?
I have, yeah.
Have you listened to all of that, and in particular, the evidence given by Mr. Thompson?
Do you mean Mr. Thompson of?
Yes, you're Mr. Thompson.
Mr. Thompson of the airport, Mr. Thompson. Yeah.
Yeah, thank you. So just to have a recap, really, to see where your evidence takes us, if at all. It's agreed, isn't it, that Terma, and this is not, I'm not asking you for a technical input. You've told us you're not a technical, giving technical evidence, but this is just where we are with the evidence that we've both heard. Terma, it's agreed, is going to provide 90% plus probability of detection. Agreed?
I think there's a high likelihood of that, yeah.
Well, it's been agreed by your witnesses, hasn't it, that it will? So
I think that's fair, yeah. I think that's fair.
Thank you. And there's capacity. So
at the moment, yeah.
So there'll be capacity at the moment, and you heard that it was also agreed that decisions should be made as of now. So the regulatory position as it pertains now, not sometime in the future. That was very clear from Mr. Fido, wasn't it?
Decisions in terms of what?
Well, decisions, the planning decision has to be made now, and that's in light of the current situation and all material considerations, the planning decision now. But Mr. Fido also said any decisions in relation to regulatory compliance. That's as the regulations are now, not at some point in the future. I can take you to his answers at Clauchrie and cross-examination, which you agreed if you want. But would you be happy to accept that that's what he said?
Yes, I'll take that as what he said.
Thank you very much. Now, Mr. Thompson, in response to questions that I put and then the reporter put, agreed that the 3 mitigation steps which are put forward by the applicant at a cost which have been costed up by us. The words were there or thereabouts, or in that ballpark, at 60k, are sufficient to enable him to put him in a position to withdraw his objection. You heard that?
Well, I think there was some debate about what was and what wasn't said, and obviously the recordings are available for people to go back.
There's no debate. I mean, you heard my interjection in relation to what I thought was inappropriate re-examination of Mr. Brown, but it's quite clear what was said. And the note is, and we've checked it, all of us say the same thing, and the note, no doubt, the recording we've watched it says the same thing, that the 60k for the 3 items of mitigation proposed by the applicant would put Mr. Thompson into a position whereby he could remove the objection. That was his evidence, wasn't it?
Well, I didn't interpret it in that way, but
how did you interpret it then, Ms. Kilpatrick? Because let's see whether you are being fair in the way you give your evidence.
Well, I think he was, having listened to it, I think there were some cross wires, and I think Mr. Thompson thought he was talking about the safeguarding steps. You were clearly talking about the conditions, and because he does refer to information that was passed to Aegis, I think, or maybe it was direct to community wind power with reference to those safeguarding steps. Mr. Thompson doesn't provide information on post-construction costs because that's something we normally do. So on that basis, I think he believed that he was talking about safeguarding steps.
You're trying to rewrite evidence, Ms. Kilpatrick. Or the question is this: what Mr. Thompson said in his response was that the 3 items of mitigation are very clear what they are. So that includes post-construction optimization and validation. 60k there or thereabouts, that would put him in a position to remove the airport's objection. That is what he said. Whether you think it's different, whether that bothers you or whatever, that is what Mr. Thompson said, isn't it?
Sir, if I may,
Yeah.
I hesitate to interrupt, but this is obviously a contentious issue here, and I have been through the notes, and I have to say that there will be submissions about what was actually being agreed and how it was, or what was being discussed and how it was being discussed. So, sir, I'm asking that this evidence is heard under reservation so that it can all be reviewed when it comes to submissions.
I've listened back to the recording. I've got my own view of what was said and what wasn't said. I'm content for Mr. Hardy to pursue the issue so we understand what the different understandings of that evidence was. I think that is important to hear now.
Yes. So that's I'm very grateful. Thank you, sir. So I've got a very clear recollection. That's what's coming in submissions. So your take on that, I mean, obviously that would cause you a big problem if my interpretation is right, Mr. Kilpatrick, but you want to try and put a gloss on it. So that gloss is what?
You asked me what I thought Mr. Thompson had said, and you clearly will make submissions, like you say, based on your understanding what was said. When I listened to it, I thought he was talking and describing the safeguarding steps that he would normally talk to a developer about.
Mm-hmm. All right, well, let's leave that there. I'm confident in the position. In terms of your own evidence this morning, it didn't make sense to me, I have to say, because those 3 steps in the mitigation that are proposed in the condition by the applicant, you said would fulfill steps 16, 18, 19, optimization step 25, and validation step 26. Yeah, that was the evidence you gave about 15 minutes ago.
So I've just got this in front of me now. Can you just repeat that again, please?
Yeah, you said that procurement would be 16, 18, 19, optimization would be 25, validating would be 26.
Yeah.
Yeah. So what you also said was that and it ties in with your your interpretation of what Mr. Thompson was saying. You said that those were the pre-construction steps. That simply can't be right, can it?
No,
Because
I said steps 16, 18 and 19 were pre-construction steps, and steps 25 and 26 were post-construction.
So if Mr. Thompson understood the and had read, and it was put to him, and he knew exactly what was an offer from the applicant, the mitigation steps, that included post-construction steps, didn't it? He can't have been talking about anything else.
Well, yeah, the conditions that have been proposed are quite clear that they include
Yes.
post-construction steps. Yeah.
So a question put to Mr. Thompson: have you read the condition? You understand the mitigation steps that have been put forward by the applicant would include post-construction steps. Therefore, your points about it being limited to safeguarding or pre-construction, whatever, simply can't be right, can they?
Well, if that is indeed what Mr. Thompson said, then he's clearly given an answer in that vein. But
yes,
making the point that I think there were cross wires. I appreciate that that's evidence that's being given.
Yes, well, evidence is all we can go on, and witnesses take their chances, Ms. Kilpatrick. Now, those will do in terms of the summary where we've got to, and really, if we're right in saying that that mitigation is sufficient to put Mr. Thompson, who's the MATS, in the position to withdraw an objection, everything after that is in, I'm going to just loosely call it another category, isn't it? Whether it's profit, war chest, future risk, or whatever it is, it's in another category, isn't it? They're not steps required to make this scheme acceptable in terms of safety. It's in another category. Do you at least agree that?
Well, there will be steps that are required to maintain the acceptability of safety while that development is in the environment.
Just bear with me in terms of the division. So a condition required to make something acceptable, which otherwise would have been unacceptable, to in terms of making the position safe. If it's accepted by the airport through Mr. Thompson that those 3 steps are sufficient, everything after that is another debate, isn't it? It goes into another category, whatever you want to term it. Not going to get hung up on that, but there's a division, isn't there, at that point?
But the acceptability comes after the mitigation agreement has been entered into.
Well, we'll come on to that. That's a completely different point with respect. You see, getting to a point where an objection can be withdrawn, that's the test, isn't it? Because what's required in the planning world, you're not a planner, but in the planning world, that's what's required to withdraw an objection. Planning consent could be granted. Anything after that is in another category. It might be nice to have. You want to have some money, I get that. But that is not, that's in a different category, isn't it?
Well, again, like you say, I'm not a planner and I'm not a lawyer either, but our advice is that there is no policy that states that the airport should bear the risk that comes as a result of the development. But I'm not a planner, and as I've said to you, our advice is that the condition that's been put forward is lawful.
Yeah, you're prepared to share that advice. You see, I'm going to obviously can make my submissions, and I think that that's absolute rubbish. But do you want to put the legal advice in? It's a matter for you, don't have to, but are you prepared to share that legal advice?
Well, I'd need to consult and see if that's appropriate.
All right. Well, it's a matter that obviously for the airport to consider. In terms of, I suspect I know what the answer to this is going to be. Wind farm mitigation agreement. What we do know about this, because there's another piece of evidence that we've got. Mr. Thompson confirmed that even in its 3rd iteration, that's on a per megawatt basis, isn't it? So the overall charging structure is a per megawatt basis.
Yeah, it is.
So are you prepared to divulge the wind farm mitigation agreement to this reporter in its 3rd iteration?
Well, I'm happy to put it to the reporter, but I can't.
No, to the inquiry. Obviously, it's got to be in public.
Yeah, I know. I understand that. And I think I've been clear, and I was clear at Clauchrie, that because we're bound by confidentiality, I can't share that agreement.
Yeah. So obviously, I'll put the points down. I know what the answer is going to be, but it's got to be recorded because it will come back in submissions and potentially a cost application. And I want to give you the opportunity to respond properly. So you are not prepared to put in the wind farm mitigation agreement in its third iteration.
That's correct.
Okay. We know from Mr. Thompson that it's a per megawatt charge. Are you prepared to give any other details of what's in the WMA?
Well, it's an annual charge. It is a per megawatt based charge. We have taken account in the latest iteration of the increasing capacity that turbines have, and have reflected that by applying a cap to the turbine charge. There's a maximum per turbine, which should then even out that measure. I can tell you that the charges are less than the charges that have been stated by Mr. Thompson from DWP, but I'm not obliged to share those, to share the agreement in front of the inquiry because of the confidentiality.
Of course, that's your choice, but you know, the consequences of that are probably for the lawyers and not for you. But your evidence is there, is clear. Bandings, are you prepared to tell the report about whether there are bandings depending on the size of the output?
Yeah, there are bandings.
What about bargaining power? So do developers, well, whoever they are, get treated in the same way, or is there room for negotiation?
Developers do get treated in the same way. Obviously, terms of mitigation agreements are not just about costs. There are lots of terms in there that are negotiated. The higher bands, there may be some negotiation about those, but the lower bands, they are fixed.
So whoever you are, you get taxed the same. Is that the principle?
Well, I wouldn't call it a tax, Mr.
Well, other
Hart.
airports do, don't they? They're more open. I've been dealing with these sorts of things for about 20 years. Turbine tax, that's what it is. It's you put a turbine up and you charge per megawatt. That is it's a tax, isn't it? Let's call a spade a spade.
Well, I've never heard an airport or an ANSP refer to their wind farm mitigation agreements as turbine taxes. You may well have, but I certainly
All right.
haven't.
Well, that's something that I'm not going to give evidence, but that's I'll leave that there. In terms of the what do you actually get? Let's just answer that. So this applicant, as I say, suspend disbelief, enters into a wind farm mitigation agreement, right? What does it get?
Well, the applicant will get what it gets from the mitigation agreements it's signed into with the likes of NATS and MOD. It gets to place its turbines in locations that it deems to be optimal, that are not optimal for the airport, on the basis that it causes an impact.
It's not really the question, Ms. Kilpatrick. What do you get? What does it get in return? So law of contract, it signs up, pays you loads of money. What does it actually get? Apart from buying off, let me put it, apart from buying off you as an objector, because obviously it gets that out of the planning system, but what does it actually get in return? Well, the actual, what's its consideration?
Well, I think we just have to bear in mind that the development creates a huge impact on the airspace in which the airport provides air traffic services. That impact has to be dealt with because the airport has a regulatory obligation to provide safe airspace. Now, the DFT is very, very clear that the cost of mitigation should not be borne by either the government or by airports and ANSPs. It should be borne by the developers who benefit commercially from the activities of that development. And it is not right and proper that the airport is burdened with those costs on that basis.
Yeah.
As far as I'm aware, no airport or ANSP would accept that. The applicant, your client, has just entered into a mitigation agreement, it would seem, on this development with another ANSP. clearly couldn't share the terms of that to explain why that was different, or how they perceived it to be different from mitigation required at Prestwick, and I understand that because it's bound by confidentiality. But this is a common practice between the sectors to deal with an issue, a tension between a developer who, through its commercial activities in generating renewable energy, has an impact on airspace that needs to be dealt with.
It's a very long answer. I mean, there's a number of points there we need to go to. In terms of your understanding of policy, I'm afraid that's wrong, and we'll go to why that is. In terms of other practice of other airports have been challenging these sorts of hostels, if I'm going to put it colloquially, for the last 20 years. So just because it's standard practice doesn't make it right. We'll come back to that. What the real question was, what does this applicant get for entering into the wind farm mitigation agreement? What actually is it getting in return? If that's a difficult question, let me put it this way. The airport says that there are impacts of having the turbines located where they are, and one could understand if a wind farm mitigation agreement gave access to some magic technical mitigation or something of that sort. You were buying something to do something different, then you could understand. But it doesn't, does it? Those impacts, shadowing, impacts on IFP, they're all there, but you've just been paid not to object to the application. That's the reality, isn't it?
Which mean those things are already there. I mean, Terma.
Well, what do you get from the wind farm mitigation agreement? What is it that the developer gets in return, other than you as an airport deciding not to object?
Well, we need to rewind a few steps here, because we're in this position because the developer has chosen to build a wind farm in an area that creates an impact on the airspace that the airport is providing services within. So this situation does not manifest itself as a result of something that the airport's done. It needs to react and respond to that. There is an impact. Wind farms, is generally accepted, where they're in radar line of sight, will have an impact, and it will be a negative impact, and that impact needs to be mitigated, and it needs to be mitigated for the lifetime of the wind farm.
That's not answering my question, Ms. Kilpatrick. What is it that the applicant would get for entering into the wind farm mitigation? What's the consideration given by the airport other than deciding not to object in the planning system?
Well, it needs to enable, needs to allow the airport to be able to continue to mitigate the adverse impacts that the development has for the lifetime of that wind farm.
I'll try again, probably last time. What is it that it gets? Because the safety is paramount. The airport has to comply with its regulatory requirements, otherwise it can't operate as an airport. It will do that anyway. All right. This is about cost. It's just about who pays. What is it that the applicant gets from signing the wind farm mitigation agreement other than non-objection?
Well, I'm not going to change my answer then. I think
Right,
you make the point that
I've asked the question 3 times,
okay.
and as far as I'm concerned, I haven't got an answer to it. In terms of costs, the airport, other than reflecting through Mr. Thompson the 60k, hasn't put forward any evidence of costs, has it, for any item that would be included in the wind farm mitigation agreement, or indeed in the table of costs and risks? It's a bit of a misnomer. It's just a table of risk, isn't it? You haven't put forward any costing information to this inquiry, have you?
No, we haven't.
Okay. So to that extent, you'd be asking the reporter and the ministers to suggest a scheme which has got no end to it, no costing, no certainty about what actually you're asking for, because you've chosen not to do that. Well, that's right, isn't it? You could have costed it up, you see, and said, actually, let's have a debate about this. The cost is going to be X. We say Y, and then there's a decision made. You haven't put any information in, have you, at all? Nothing.
No, we haven't.
Thank you. Obviously a matter then for legal submissions. What do you know about terms of the contract with Terma? Do you know, as obviously Mr. Thompson made the ultimate decision, but the commercial terms of the contract with Terma, are you aware of those?
Well, the contract is with NATS.
Contract for the purchase of Terma then. I don't mind with the detail. Are you aware of that?
Not in great detail, no.
Do you know about ongoing maintenance or the contractual obligations that come back your way about what Terma will do?
Well, we have a maintenance program with NATS for Terma. Is that what you're referring to?
Yeah, I just want to understand. You buy the kit. Obviously, you get your system. I'm interested in what's included. So say Terma develops a fault. Is that that's under warranty, presumably?
Well, some will be under warranty and some won't.
So if you don't know about the details of those contracts, we can take it that there's been nobody before this inquiry that can give that evidence. You're the person that can give as much evidence as the airport can. Is that right?
Well, Mr. Thompson knows in detail what's covered in that agreement.
Well, I asked him, you see, and he didn't. So between you and Mr. Thompson, that's the sum total of the evidence about the Terma procurement and contracting process, is it?
Well, I wasn't aware that
Is
Mr.
anybody else?
Well, we do have an agreement for maintenance. As I said, that is in place. It will cover some things. It won't cover all eventualities.
How long can you tell us that? How long is the warranty period?
Well, there's an initial warranty with the Terma, which will have expired. I think it was 2 years. I can't tell you exactly.
And do you have an extended warranty?
Yeah, that's what I'm telling you, that we pay for that.
How long is that?
3 years, I think.
3 years. And is that capable of extension?
Yes.
In other words, it's rolling, so you'll get every 3 years the opportunity then to buy another package of warranty and maintenance.
Yes.
And is there an end date to that? Is there, certain products have a kind of block, a life where you can't go beyond 25 years or whatever it is? Do you know where the...
I'm not aware if there is or there isn't.
So actually you could have a package which Terma continue to support your the Terma system for as long as you carry on paying.
Yes, or they may not.
Yes, but they could. But in terms of evidence to this inquiry, the reporter could say, well, I don't know, you buy a bit of kit and actually these things can go on being supported as long as the applicant is prepared to pay, maybe 10 years, 20 years, 30 years, whatever it is. Terma haven't come back to you to say, so far as you're aware, well, there's a drop dead date, we're not prepared to warrant this after 20 years, say. You're not aware of that?
I'm not aware of that.
No. So the reality is you talk about lifespan and so on. Actually, Terma might still be in place in 40 years' time. You carry on paying the maintenance, you decide we don't need anything more, it does the job, you carry on paying for the maintenance program, that'd be job done, wouldn't it?
Well, that's not the advice that we've had from our technical experts, and that will clearly be for Mr. Warren to consider technical evidence that's been given by both sides on that.
Well, no, it's a contractual matter, really. It's not a technical matter. That's why I was asking you about warranty. And of course, at that point, I mean, you're an airport. Nobody's forcing you to operate as an airport. You're a business. At the point at which a radar was either refreshed or a new system was bought, it would simply have to be a system which dealt with the environment, the radar environment as it was at that stage, wouldn't it? That's your obligation.
Yeah, we have
it's the stock in trade of the airport, isn't it? You operate as an airport, you choose to, nobody's forcing you to, just as you're saying wind farm, operators have a choice. Nobody's asking GPA to operate, so you just have to take that on board as an operational cost at that time, don't you?
We have to provide safe airspace, like you say, it's a regulatory obligation, and we have to do that with no matter what is in the environment,
Yeah.
and hence the requirement for a mitigation agreement,
Well-
because once the wind farm is in the environment, it creates an impact. It's an impact we have to deal with. We have to mitigate it, and we have to mitigate it for the lifetime of the wind farm. As you say, that becomes our responsibility, come what may. That we must provide safe airspace.
Yeah, I mean, it's just a misunderstanding, Ms. Kilpatrick. It's part of the baseline at that stage, and you have to have a system. If you want to operate as an airport, then you have to have a system that can cope with it. What you can't do is stick an applicant in 2021 with that speculative cost. That's the difference, isn't it?
Well, it becomes part of the baseline because it becomes acceptable to the airport, because we have a means by which we can ensure that we can provide the mitigation that is required, that comes as a direct result of the development. And that is no different to, I would expect, the agreement that the applicant has now got in place with NATS.
Well, that's a completely different matter. I mean, NATS is, and the circumstances of that really aren't very helpful, are they? We're talking about the impacts here on the airport, so let's just stick to that. And the reality is that there are impacts which are of a development which are accepted by the applicant, which are to be paid for. What happens in the future, whether you continue to choose to operate as an airport, systems purchased in the future then becomes part of your operational cost, doesn't it? And either the business can stand that or it can't. It's a matter for you.
Well, as I've said, there are impacts that are created as a result of the development. Those impacts continue and endure for the lifetime of the development. And as you quite rightly say, we will need to ensure that the airspace in and around that wind farm has safe airspace.
Yeah, and the 60,000 deals with that, you see, that's the point.
Well, it doesn't. No, it doesn't, Mr. Hardy.
It does according to Mr.
It doesn't for the lifetime of the wind farm.
Does according to Mr. Thompson, you see, and that's the point, that in terms of the operational impacts now, those steps are sufficient to allow your MATs to withdraw the objection. What you're talking about is some sort of payment going forward because you want to tuck some money away in case of future event speculation, changes in airspace and whatever else it is. That's the reality, isn't it?
No, that's not the reality. And it's not about changes that will happen in the environment that the airport would normally have to deal with. What we're talking about.
Well, it's confusing then to me, Miss Kilpatrick, because the sort of evidence we've heard is, you heard Mr. Fido yesterday that it was about an upturn in aviation movements. That was what his concern was in capacity terms. So he wasn't bothered about the turbines themselves. It was about whether or not there's going to be an upturn in aircraft activity. We've also had airspace change mentioned. We've had proliferation of UAVs and drones, and everybody not being sure about that. So what is the case? What is the airport's case?
Well, I think Mr. Fido talked in great detail about some of the other degradations that come as a result of wind farms in the environment, particularly as we now start to see a proliferation of wind farms in a concentrated area. And those,
He didn't, with respect. Mr. Fido was actually very happy to accept. I mean, some problems with the credibility of his evidence. So leaving that aside, he was prepared to accept there's 90% PD, and that's what's required for a controller. So whatever's there, there is going to be 90% probability of detection with the wind farms in place. So that's an end of it, isn't it?
Well, clutter is one of the issues that is caused by a wind farm, but it is not the only degradation in the airspace that the ANSP has to deal with.
No, but there's nothing else that would cause him to maintain an objection. That's the point. So the only other things the airport have referred to, IFP, well, there's a report. I mean, you've seen Mr. Parkinson's evidence is authoritative on this, and that's what we'll be saying. IFP, late in the day, the airport's done a report. That's not available, is it?
I'm not aware that that's been concluded now.
No, we've been promised it, but it's that's not coming. ILS, well, it just doesn't arise for the reasons Mr. Parkinson said. Radio comms, that's been done late in the day. Not relevant either. Those are the issues, aren't they? The airport, in the entirety of your evidence, you've not raised anything else.
Well, I beg to differ, and obviously that will be for Mr. Warren to consider, won't it, Mr. Parkinson?
Well, could you identify them? You seem quite keen. Obviously, I've read everything in detail, and this week we've had 5 days. I don't see anything in the airport's case other than those. So if you want to tell us, do.
I think that, well, like I say, I'm not a technical expert, but shadowing would be probably one of the key impacts over and above clutter, which you quite rightly say Terma deals with very, very well.
Yeah, we dealt with shadow though, didn't we? And we've already dealt with that during the evidence, but fair enough. That's to add to the list. What else?
Well, I mean, we've a whole cost and risk table.
Well, we don't. We've been over that, don't we? And this is the problem, that you can't, with respect, see the distinction between what's mitigation required to make something acceptable and a bundle of risk which you want someone to pay for going forward. And we've agreed the guillotine comes down, if you like, in terms of the planning system, that comes down at the point where this scheme becomes acceptable. The fact you want somebody else to pay for things going forward is in a different category, isn't it? And that's the second time we've been over this.
Yeah, well, as I said before, I'm not a planner, and I'm not a lawyer, and this would be for submissions.
Thank you. Well, in which case, we won't take that any further. I mean, I can't be any clearer in my position. You can't really help. So we'll leave that there. In terms of the evidence that you gave at Clauchrie, so if we could just turn to that, please. So that's the transcript of your cross-examination. Similar point really to other witnesses, very helpful. I don't need to go through all of this if you're prepared to accept that this is an accurate record, and also you don't want to change any of the answers you gave to Mr. McLeod. So you had a chance to read it. Are you happy with what you said?
Yeah, I'm happy with what I said.
Yeah. And the points coming out of there in relation to finance and the accounts, we don't need to go to the accounts unless you feel you need to see the source documents there. I don't know whether you've read them, but this seems to me an efficient way of doing it. Term has been paid for. Long and short of it, there's a couple of £1 million in excess of what's been spent, isn't there, Mrs. Kilpatrick? That's where this cross-examination gets to.
Yep, that's fine. That's accepted.
Thank you. The accounts for the financial year through to 2020, they're not available, are they?
Do you mean to 2021?
2021, they're not available.
No, they're not. They're not signed off yet, published,
Yeah.
but they will be shortly.
And it's interesting to me to know what's happened in accounting terms. So just take a step back. The legal structure from the airport. There's the holding company, isn't there? And then is there the top co? There's no top co.
Holdco, do you mean?
There's the holding company. So just in terms of the structure, basically, my understanding is that it's a privately owned holding company which is wholly owned by the Scottish ministers. Is that the basic legal structure?
That's my understanding. Yeah.
And in terms of accounting practice, what I want to understand is where the money, so the excess, the money that's been given over the money that's been spent, what's happened to that? How's that accounted for?
Well, it will be on the balance sheet. I'm not an FD, but my understanding is that's on the balance sheet.
Okay. Has that been ring-fenced?
I can't tell you if that's been ring-fenced.
You can't. Okay, because you see, if the airport's case is that money is payable under wind farm mitigation agreements to for mitigation or whatever else it is, that's for a reserve purpose, isn't it? One would expect that to be shown in the accounts for reserve purpose, and I've read the accounts and it's not. So I'm interested.
I can't comment on accounting practices.
No. So when you gave your announcements, I've seen the press releases and sort of jubilance about performance of the airport and so on, the profits being made. That includes, I'm going to suggest, the unallocated wind farm mitigation payments, isn't it? I'll put bluntly, the way that you've been able to sell, of course, the airport's up for sale, the attractiveness of the airport, it's because it's been propped up by wind farm mitigation payments, isn't it?
Well, I don't agree with that, Mr. Hardy.
Well, if you can't agree, if you in terms of the accounts, because obviously people look to the accounts, you aren't in a position to tell us how that money is accounted for. I'm not sure how you can answer the second question, because you can't tell us where that money or where the operating stream or the operating profits are shown to come from, can you?
Well, I think what we said at the start of this conversation was the income was about £8.2 million, and the expense so far has been about £6 million in total. So there is a surplus, if you want to put it that way, of £2.2 million.
What's profit? Let's call it. It's profit, isn't it?
Well, it's not profit if you're going to incur costs.
But that would have to be referable to your objective, and what you're not able to tell this reporter is that is actually reserved for a purpose. It's just gone into the funds, hasn't it?
I've explained to you, Mr. Hardy, that I'm not an FD.
No. All right. Well, I can make my submissions on accounting practice because I do understand the accounts. I think, Ms. Kilpatrick. Right. In terms of the payments that are due, so I think one of the answers to Mr. McLeod was that he was asking, well, look, what are you expecting in terms of the years going, so 2021, the 21-22. Are you able to, I know the accounts aren't finalised, but are you able to give an indication of the sort of sums that will be coming in?
Yeah, I can give you an indication of the sums that will be in the accounts that have not been published yet.
Thank you. Yeah.
That will be somewhere, I think, in the region of 0.9 million.
0.9 million.
0.9 million. Yeah.
That's coming from what I think are termed as the misnomer is wind farm services, but actually that's from the mitigation payments, is it?
It is a mitigation payment, yeah.
Payments.
Payment.
Yeah, is that a single wind farm that's contributing 0.9 million? Because that tells us how much they're having to pay, or is that a number of wind farms?
No, it'd be a number of wind farms.
I think there are 9, aren't there? So just on a pro-rated basis, that'd be £100,000 per each of those 9 wind farms.
Well, no, because there's different styles of agreements. You're talking about
that's fair play. That's just a straight division. You're saying some of the old versions, actually, some of the other wind farms are going to be treated differentially in terms of their payments under the different iterations of the agreement. Is that? But what we do know is that 900,000, that 0.9 million results from 9 wind farms, doesn't it?
No, it doesn't result from 9 wind farms.
How many wind farms does it come from?
I think it's 2.
2.
Well, I can't. Well, I'll reserve my answer on that because I can't tell you off the top of my head.
Right. So the other operational wind farms then don't pay at all, because there are 9, aren't there?
Do you mean the development
operational wind farms at the moment? Those wind farms which are impacted. I may be wrong in that figure number. I think it's 9. So we had all of those video sequences showing the turbines and all of that stuff. There's 9 existing farms, all having an impact on the radar. You're telling us only 2 of those then continue to pay or pay under the or under any form of WMA?
Well, they were the MA1 and MA2 were lump sum based payments where the payment was made upfront for the mitigation services, not an annual ongoing recurring charge.
Yeah, I understand that. There was the debate about capex and the nature of it. Not all wind farms, of course, were asked to pay contribute anything at all. Plants, some of the wind farm, included. But in terms of the number of wind farms, there are 9. And what you tell us is that the contributions coming in 2021 come from 2. So that would mean that, if that's right, that would mean that there are 7 farms that aren't paying any ongoing contribution. That would be right, wouldn't it?
Well,
Just
it's
fairly straightforward.
Those, do you mean, right? So though the first 2 agreements were lump sum capital contribution based agreements, where the developers paid upfront for the mitigation charges, and the new form of agreement, the MA3, is an annual recurring charge.
Yeah. So my point, I understand all of that, obviously, is that I asked you about money that was coming in the accounts yet to be published. And what you told me that was 0.9 million, 900,000. I suggested £100,000 for the 9 wind farms. You then told me, no, it comes from 2 wind farms, right? So if there's 9 operational wind farms having an impact, that would suggest that there are 7 that aren't making any ongoing payments. It's just a matter of logic. That's right, isn't it? That must be right, isn't it? If there's 9 wind farms, there's 2 that are contributing. 9 minus 2 is 7. There's 7 that ain't paying. That's right, isn't it?
Well, there's a very, very, very small annual contribution on the very, very early agreements, which would also be occurring, but that's a very, very small.
0.9 million. Do you know how many wind farms caught by that and what that figure is?
I can't tell you what that figure is.
All right, but it sounds very small. It certainly wasn't one that you mentioned. So the point is this, that on that evidence, there's a 7, maybe 6, whatever it is, wind farms that aren't paying on an ongoing basis. That's the state of play, isn't it?
Yeah, because their contribution or remuneration or charge or whatever you want to refer to it was paid in a lump sum.
Yes, but it doesn't sit with your evidence, does it, about ongoing impact? Those turbines are still there. Whether you were able to leave a capex out of them to buy a system's got nothing to do with ongoing safety. Your case is that the turbines are there in the environment causing a problem. Those developers aren't paying anything, are they, towards that problem that you say exists?
Well, that's why we changed the form of the agreement to be an annual recurring payment, because we recognise the fact that the early contributions had indeed been used to purchase the wind farm radar tolerant system. So that had been acquired, and we then felt it was more appropriate to move to an annual recurring charge in recognition of the fact that the costs and risks endure for the lifetime of the development.
Yeah. So what you want to do now is change the rules effectively on your side, and then stick the current crop of developers with costs which you don't get from previous wind farms, which are contributing to the problems, the longer term problems that you say exist. And put crudely, that's right, isn't it?
Well,
it's a hustle, isn't it? Let's go to Mr. Cooper. What it is that you want to have some money from developers on a turbine tax, and that's an end of it.
Well, I don't agree with you, Mr. Hardy. So we'll agree to disagree on that.
Yeah, okay. That's all I really want to ask on your. So we'll just take your Clauchrie cross-examination as read, and I can make some submissions on that. Letter.
Mr. Hardy,
yes.
Before you continue, I just wonder would that be a good opportunity to break? I'm conscious we've been going for a fairly good amount of time now.
Yeah, absolutely.
Okay, I'll suggest we break for 15 minutes, so we return at 11:20, so just over 15 minutes. Miss Kilpatrick, if you can not speak to any of your colleagues during the break, please, but you're welcome to turn your video off and have a break, okay?
Thank you. Cheers.
Thank you. Okay, welcome back, everyone. And can I thank you, Mr. Brown. You knew what I was going to ask. Just to see that you're there. Mr. Hardy, are you with us? Hi there. Okay. You can restart whenever you're ready, Mr. Hardy.
Thank you very much. So I've consolidated notes. Mr. Kilpatrick, I've got 4 relatively short topics I'm going to deal with. The first one of those is policy. And you are quite keen on telling us that government policy is that for onshore wind is that the developer should pay the cost of mitigation. Yeah.
No, I said the DFT's position on the cost of wind farm mitigation is that those should be borne by the developer who benefits commercially from them.
Well, let's have a look at what actually that is. So if we go to CD 19.93, so that's in the GPA documents.
I don't have that. I'll need to get that document.
Could find that. It's obviously a document that you are aware of because I assume it's the basis of your statement.
That's fine, Mr. Kilpatrick. Just once you've found it, just let me know.
Yep, that's fine.
Do you have it now?
Uh-huh.
Ah, great.
Good. So just to confirm, this is the basis, is it, of your proposition about where costs should lie?
Well, I spoke to well, yes, that is obviously a record of the position. I spoke to the DFT probably about 2 weeks ago, and they confirmed that that their position as to the costs of mitigation and who should bear them has not changed.
So that's interesting in terms of your language, mitigation. Let's just pick up on that. So, I mean, this is not, there isn't policy. Let's be clear, Mr. Kilpatrick, what this is an answer to a ministerial question, but it's helpful to our case anyway. Let's look at it. Michael Ellis, Conservative, and the question was put by Peter Aldous. I think there's a little bit of that question which is clipped off the end. But to ask the Secretary of State, with reference to the government's offshore wind sector deal, published in March 2019, whether his department has allocated funding to help the renewable energy sector mitigate the effect of aviation radar on the development of. And then there's been some email correspondence, hasn't there? That sentence finishes off with with reference to offshore wind farms. And then the answer, 3rd of July 2019, current government policy in regard to funding mitigation of wind impacts on radar is that mitigation costs recover from those wind farm developers who stand to benefit commercially. So a number of points. First of all, it's a ministerial statement, isn't it? Or ministerial response, it's not policy.
Yeah, it's a ministerial response.
Yeah, there's no policy document underlying that you want to refer to?
No.
Okay. Secondly, it's in the context of offshore and in relation to the offshore funding package that was announced.
Yeah.
Yeah, not onshore. Third thing is that it relates to mitigation, which mitigation costs, that's cost recovery, isn't it? The mitigation cost recovery from wind farm developers who stand to benefit commercially. Yeah.
Yes.
Thank you. Let's have a look at what you're trying to do and how it sits with that. If we could go to the GPA inquiry statement. So that's the first document.
Yeah, I have that.
And what role did you have in writing the statement?
Well, it was done in consultation with our legal advisors.
Did you see the document before it was submitted?
Yes.
Do you agree with it?
Yes.
Okay, right. If you turn to paragraph 34, internal page 12.
Yep.
this is requirement for wind farm mitigation agreement. The airport, in keeping with the practice of other airports and ANSPs, entered into wind farm mitigation agreements with developers, resulted in payments being made. However, until recently, one-off payments, etc. Now the airport has installed a WFRMS. It recognises a different approach is appropriate. It therefore proposes that the applicant should enter into a wind farm mitigation agreement which obliges the applicant to pay annual recurring charges to compensate the airport for the cost and risks which it bears. So compensation for risk is not cost recovery within the ministerial response, is it?
Well, the cost of mitigation is not just limited to clutter, Mr. Hardy. There are, many other degradative effects that the wind farm or the wind turbines have on the airspace that need to be mitigated. It's not just about the Terma radar.
Well, not really, Ms. Kilpatrick, because as Mr. Thompson, and we go back around in circles, Mr. Thompson has indicated in order to make this safe and to put him in a position as the MATS to remove the objection, 60,000 and the 3 mitigation steps are required. What you're talking about is payment for something else. And it might help just to refresh your memory about the answers you gave Mr. McLeod on this in the cross-examination at Clauchrie. And if you want to go to that. It's internal page 4 of that cross-examination.
Yeah.
Starts at the top of that page. To be clear, no confidentiality agreement between the airport and the applicant. No. So my question to you, what level of charge? You say, I've already explained commercially sensitive information. And then you get asked this. Okay, your position, I've heard you refer a number of times to exposing the airport to cost and ongoing cost and risk. Your recognition makes it quite clear that we're not looking at a cost recovery situation. Are you willing to accept that? Yes, you say. So you agreed with me that your evidence was accurate at Clauchrie. Therefore, you've accepted that what's being sought is not cost recovery. Therefore, it falls outside the terms of that ministerial response, doesn't it?
Well, if you actually read the full response there, you'll see that what I was referring to there was the cost of staff's time. So we put a value on our staff's time. Employees are there to add value to the organisation, and we value their time over and above the salary that they are paid.
No, with respect, Ms. Kilpatrick, that's an answer you do give, but the question was in the context of general risk. So wind farm mitigation agreements, risk, ongoing cost and risk. And that was the way the question was put. And you were quite clear in saying that actually that's right. It's not about, it's not cost recovery, it's something else. And obviously that evidence can be read by this reporter. Next question is in relation to, or next topic is in relation to NDAs. And what you tell us, this is your firm position, is that it's, we can go to your precognition and it's paragraph 24. I mean, it's in a number of places and it's writ large in your evidence, but just a documentary reference is paragraph 24.
Yeah.
The airport remains willing to have discussions with the applicant about the terms of a mitigation agreement, but before it can do so, it requires the applicant to enter into a non-disclosure agreement. So position is this: no NDA, no discussion. That's your line, isn't it?
Well, we're bound by confidentiality and NDAs with other developers, which means that we need to follow that same principle. So
well, no,
yes.
because with respect, the whole system might be wrong. What you're choosing to do is you've created this whole situation. Didn't need to have NDAs with anybody. But the situation, so far as Sankatu is concerned, is that if the applicant doesn't enter into an NDA, you will not discuss a wind farm mitigation agreement. That's it, isn't it?
That's correct, and we
Yeah.
tried very, very hard to reassure the applicant of their concerns for the NDA. We asked the applicant to mark up the NDA, which they were willing to do and did do. They accepted those markups.
Yeah.
But ultimately, the applicant didn't want to sign.
Yes, absolutely. And on legal advice, I put my name to that.
Mhm.
The reason being that the system is wrong, Ms. Kilpatrick, and those obviously submissions. And all I'm interested in at the moment is that you would not enter into discussions about costs or mitigation absent signature of an NDA with Community Wind Power. And that's correct, isn't it?
That is correct, yeah.
Thank you. That's a system which you've created, and it was open to you, wasn't it, to have discussions about mitigations, about costs and all the rest of that. Could have been done in open correspondence, indeed could have been done during this appeal process, but you steadfastly say we're not doing that. No NDA, no talk. That's the way it is.
Well, like I said, we tried very, very hard to.
No, if you just stick to the question, Ms. Kilpatrick, it's no NDA, no talk. That's the policy, isn't it?
Yes, and like you say, it's a policy that we have, and we need, you know, we have other confidentiality agreements that we need to be mindful of.
Yes, and either that will be accepted as a reasonable thing to do by the ministers, or else that system might fall apart. That's the risk that you're playing at this inquiry, isn't it?
Well, I mean, I am told by, you know, by our legal advisors that that's a perfectly normal process.
Yes.
So again, like you say,
I disagree with that legal advice. Obviously, it's a matter for submissions, and it'll be for the ministers to. And if it does go wrong, of course, then the system would get disassembled, wouldn't it? And you wouldn't then. I can't see many other operators signing up to NDAs and WMAs with you, because they wouldn't need to, would they? If we carry the day, or SPR and we carry the day, that'll be the end of the game, won't it? I think that would be the point, wouldn't it? That if this goes wrong for you, then it will be difficult to see how developers would then enter or play the game with NDAs and WMAs in the future, and that's the risk you're playing with.
Well, you're quite right. It does set a precedent, and the outcome of the inquiries, I think, will set a precedent. Although,
yes,
we obviously have to wait and see what the outcome of that is, and that, to be frank, is why we're at public inquiry. It's not something that anybody wants to go to, but the position we find ourselves in, and we found ourselves in with SPR, and we find ourselves in with the applicant, is that they are not willing to acknowledge that there is any impact of their development beyond initial optimization of the radar. So the NDA issue, and talking about cost, is somewhat lost in that, because there's a fundamental disagreement on the position, and that is that both SPR and Community Wind Power believe that beyond initial optimization of a terma, there is no impact from their development. There are no costs and risks associated with that should be borne by them, and we have a very different view.
Yes, what I mean, to put it plainly, what we say is that we're complying with planning law and decision making, and indeed government policy about cost recovery, and what you're trying to do is something completely unacceptable and different. I mean, that's the difference. That's what cutting to the nub of it, or getting to the nub of it, is the difference between the parties, Ms. Kilpatrick. If you want to answer, go on.
Well, I'm just going to say, I think it's a fundamental difference of opinion on what the impact is.
No, Ms. Kilpatrick, it isn't. The impacts, cost recovery for mitigation that's required, and it's the fourth time I think now we've circled back to this. Cost recovery for what's required to enable the MATs to withdraw the objection is the 60k there or thereabouts, and that is mitigation. That's cost recovery. We put our absolutely prepared to pay for that. Beyond that is something else. That's compensation, and we're not. That's the difference, isn't it?
I think that's quite an interesting point, because when Mr. Thompson from Community Wind Power was asked by the reporter about conditions and about whether or not he would be prepared to accept a condition that, if in the eventuality that there was some risk that could be directly attributed to the development, would he find that acceptable? And I think his answer to that was that he wouldn't find that acceptable, because it would be uncertain as to any timings or costs, which, you know, I find interesting that the applicant wants it both ways, wants to make a case that there is no risk going forward that would be attributable through the development, but yeah, isn't happy to accept a condition that would mean if that did actually happen, they would have to bear the cost of that.
You're confusing two matters. We'll deal with that wording of the condition at the condition session. The third topic then is in relation to non-engagement, which I'm interested in. That's your paragraph 23 onwards. And for that, I'd like to go to there's a couple of letters. So that's APP 02009. So if we could head to that, please.
Is that the CMS letter?
It is. Do you have that?
Mm-hmm.
So that's a letter written 30th of July of 2021 and written to Mr. Blythe. He's the partner at Denton's. He says one of the two firms that provide you with advice. Yep.
Yep.
And you'll see that in that, as you scroll down the letter, just getting to the relevant part, that an offer is made for payment of £60,000, isn't it?
Yep.
And that is in relation to the elements of mitigation that have been put forward by the applicant at this inquiry. And those are the three elements that were put in the questions from myself and the reporter to Mr. Thompson. So £60,000, he agreed there or thereabouts. That offer was made in that letter, wasn't it?
Yes, it was.
Okay. All right, let's have a look at the response then, which comes from Denton's. That's the next one on. That's the 12th of August.
Yep.
And I read the letter very carefully. It's a simple point. You don't respond, do you? Or Denton's don't respond to the offer of £60,000 for the mitigation, which Mr. Thompson said would remove the object, or put him in a position of removing the objection. There's nowhere in that letter that is responded to.
Well, I believe that there was a response to that.
Where was that? Could you take me to it? In any of the, because it's a more general point, where do I find any correspondence where you have come back to the applicant about the £60,000 mitigation cost, and whether, if that was paid, you'd be in a position to withdraw the objection? Because I haven't found it anywhere.
Well, I'll take your reading that there isn't a direct reference to that
Anywhere. I mean, I'll make a point. If you obviously don't want to put you on the spot unfairly, if you think that there is a letter that I've missed or that my client hasn't brought to my attention responding to the 60,000, then obviously you can. But the submission is going to be this. Given the evidence that Mr. Thompson has given, we don't need to be at this inquiry at all, because the offer has been on the table and you simply haven't responded to it. That's right, isn't it?
Well, I'd need to take a closer look.
All right, but if you do that, if you want to find any, of course, do some homework, find any letter responding to that offer, do so, because it's important and it will come back in submissions, and as I say, likely an application for costs. Reputation next. I'm interested in an article which is in the, so it's APP 002014.
Yeah, I have that.
Thank you very much. And you heard the question I put to Mr. Thompson on this. He said that he didn't want to deal with it. Now, I'm not. It's just a newspaper report. Of course it is. That's all it is. Then not technical journalists, aren't planning specialists, they're not lawyers. But what it is a record or a document that's in the public domain, which airs the sort of debate that we're having here and accusations which are fairly strong against the airport in the public domain. And what I'm interested in, you're the commercial director, whether or not you're aware of reflection by the board on, is this the sort of thing we really want to be doing, given, and I dare say you'll get the same when closing submissions are written. There's going to be exactly the same punchy material in there, whether it goes out into the domain again, whether or not the airport had reflected on that and thought, well, actually, is this the right thing to do? Are you aware of conversations at the board level?
Well, of course, the public inquiries are discussed at the board, and nobody wants to come to a public inquiry. Who would want to have to go to a public inquiry? But we are in this position because we have got a fundamental disagreement about the impact that the development has and who should bear the cost for that. And clearly this will be for submissions and we'll both make our cases, but there is a fundamental difference in opinion about the impacts that wind farm developments have and the costs and risks that are then transferred to the airport once those developments are built.
Well, or alternatively, it isn't that's the sort of nice way of putting it, that actually the airport's desperately trying to cling on to an income stream, and that the capex for the radar is obviously gone. That's out of the accounts now. All it's got left is an argument that somehow you can stick the this future bundle of risk which is identified on developers, and you can't give in, because if you do that, the golden goose stops laying the eggs. That's where the airport is, isn't it?
No, and I completely disagree with that. Clearly that's for Mr. Warren to make a decision on and a judgment on, having heard everybody's evidence. But the airport's position quite clearly is that wind farm developments, when they're in radar line of sight, have an impact on the airspace. And that impact needs to be mitigated. And in mitigating that for the lifetime of the wind farm, the airport incurs cost and risk, and that should be borne by the developer. Now, you clearly disagree with that, and that's obviously for submissions.
Yes, well, we've heard all the evidence the airport wants to put in trying to justify that submission. We're now at the end of this. That's the end of my cross-examination. Thank you, Ms. Kilpatrick. Very forthcoming.
Thank you.
Thank you, Mr. Hardy. Ms. Kilpatrick, I'll give you a short breather whilst I just go through my notes, because a number of my questions have been answered. I'll just need to think what else I still need to ask you before you stand down. Okay, so I think I need to, so I've got some outstanding questions about, I suppose, the internal processes and the order of things in terms of how the airport handles its consultee role and the objection that's been made in this case. I should probably just be clear as well. When I'm referring to Mr. Thompson, I'm talking about the airport's Mr. Thompson and not the applicant's witness. So once an objection's been made, and Mr. Thompson outlined how the objection in this case was formed, is the airport's ultimate aim to be for the applicant to address the identified impacts in that objection, whether that's through further assessment or direct mitigation or covering the cost of the airport doing this?
Yes, so it's The mitigation agreement is to cover the cost of addressing the issue, but addressing that issue for the lifetime of the wind farm.
Okay. So at what stage in the consultee, like forming the consultee response from the airport or the objection process, were the further costs and risks in the table identified as resulting from the Sanka 2 wind farm?
Sorry, can you just repeat that again, Mr. Warren?
Yeah, sure. Yeah. So at what stage? So when the airport was forming its consultation response and decided to object, were the wider costs and risks? So we heard from Mr. Thompson yesterday about the operational impacts and the mitigation that would be required to address the kind of the sort of day one operational impacts, and that triggered the objection, is my understanding. At what stage were this? So we've got the costs and risks table that's been presented to the inquiry. How were they identified as being generated by or applicable to the Sanka 2 wind farm?
Well, some of them come as a result of the aggregative effect, which you'll see. I mean, some of those steps are very clearly directly related to, and just uniquely related to the development. But there are quite a lot of the costs and risks that will come as a result of the proliferation of development, of which Sanka is one. Now, we don't know at the time that the planning application is in what the environment will be like when that, if it is consented, what the environment will be like when that development is built, and also there's uncertainties to the impact of some of the other degradations until the development is built.
So in terms of we've looked at the flowchart this morning, which is helpful, and you've helpfully clarified the different steps and what's covered by each step. So just on sort of extending that last question, so at what stage was the need for a wind farm mitigation agreement identified, and what was the internal process or the trigger for seeking this? Does the objection, does there need to be a objection made in the first instance to then move forward to consider the need for a mitigation agreement?
Yes, so the objection is made, and then following that objection, we would expect to start a discussion with the developer, both on the mitigation but also on the safeguarding assessment to move the process forward.
So in terms of the table of costs and risks, could or would any of those costs and risks present themselves regardless of whether essentially those day one operational impacts identified in the initial objection, could those costs and risks exist despite whether or not those initial impacts would arise or not?
Do you mean could they exist in addition to those?
Could they arise without those initial impacts? So those specific initial operational impacts that Mr. Thompson identified, if they hadn't been identified, would the costs and risks in the table, or some of them, still exist regardless of that from Sanka 2?
Yes. So if well, I'm not technical enough to understand if there were no objections, if there was no radar objection, and none of the other objections, I would that would be because it's not within radar line of sight. as are, I think, about 32 of the turbines within this development not in radar line of sight, and therefore we're not objecting to. And I would need, obviously, somebody technical to concur with my response, but my assumption would be if they're not in radar line of sight, then it would be very unlikely that they would cause any of the other issues.
Okay, that's helpful. Just check my other questions. So presumably, based on what you just said, then if that initial objection hadn't been triggered, there wouldn't have been a approach to the applicant to seek a wind farm mitigation agreement in that instance. It is on the basis of there being an objection in place.
Yes.
So once just I think probably my final question would be in terms of the organisational structure of the airport and kind of lines of command. So once an objection has been made, who ultimately thereafter takes the decision on whether or not to maintain the objection?
Well, we have the process that you referred to a second ago, CD 19.25. The objection is made, and we get down to the some of the later steps there. There's engagement with the developer. That would be engagement both to discuss the mitigation agreement, and then there would be the engagement to start moving forward with the safeguarding assessment, conducting the baseline trials and the radar data analysis. Following that, agreeing the mitigation agreement. After that would come the Terma radar modelling assessment, which then would provide the overall PD figure. So on the basis that mitigation agreement is in place and the PD figure satisfies Mr. Thompson from a safety perspective, then the objection is removed.
If you're in a situation, as in here, where you have, I suppose, from a operational objection perspective, from that day one operational perspective, you potentially have moved close to being satisfied that the issues are addressed.
Mm-hmm.
But there's the absence of the wind farm mitigation agreement. Are you in a situation where Mr. Thompson's, in terms of his role in the airport, which I appreciate is, it's his one particular role, he may be satisfied, but there are wider considerations to take account of, and without that, with the wind farm mitigation agreement, you feel that they're not accounted for sufficiently?
Yeah, he would be satisfied for day one, but he wouldn't be satisfied that there would be an ongoing provision to account for the additional cost and risk that the development will undoubtedly bring over its lifetime.
So in terms of, so who in the airport ultimately withdraws the objection if for example the wind farm mitigation agreement had been signed?
Be Mr. Thompson. So it'd be Mr. Thompson that does that.
Okay.
Finishes that engagement.
Okay, thanks. Thank you, Ms. Kilpatrick. I don't have any more questions for you. Mr. Brown, would you like to offer any re-examination?
Yes, sir, if I may, I've just got three questions. Now, Ms. Kilpatrick, it was put to you by Mr. Hardy that the airport's not put forward any cost to the inquiry, and that was with reference to your table of cost and risks. And you answered that by saying no. Can I ask you why no costs have been put forward?
Well, because we are under confidentiality, can't provide the details of the mitigation agreement in a public forum.
Okay, thank you. And you may remember that at one stage in your cross-examination, there was discussion about the £8.2 million figure and the fact that about £6 million had been spent on expense. You remember that?
Yeah. Yep.
And I have you noted as saying that, so there is a surplus, if you want to put it that way, of £2 million. And Mr. Hardy said to you, it's profit, isn't it? And you said, well, it's not profit if you're going to incur costs. What costs do you have in mind there?
Well, I think I mentioned them in my recognition. We need to, and this is to take the radar back to the level of performance that we have from the current S511. We need to invest in a dual channel, which we have on the current radar and don't have here. I don't have exact costings, but it's not gone to tender, but it will be, I think, expect to be somewhere in the region of about £1 million. And then we believe at the moment, based on the trials that are currently underway, that we will need to invest in a PSR infill feed at some point in the not too distant future, and that will be an ongoing annual charge. Again, I don't know the absolute amount, but it will be well into six figures annually.
Okay, thank you. And my third and final question is, you were taken to the letter from CMS to Mr. Blythe, dated the 30th of July, which is APP 2-9. Remember that?
Yeah. Yeah.
And you were also directed to APP 2-10, which was the response from Denton's.
Yep.
And I believe it was put to you that the offer contained in CMS's letter of 30th July wasn't responded to. Remember that?
Yes, I do. Yeah.
Could I ask you please to turn to page 6 of the letter from Denton's to CMS, which is APP 2-10.
Yes, we've got that.
And could I ask you, please, do you have the section which is headed conclusion in that letter?
I do, yeah.
Yeah, so just read that conclusion, please.
The airport hopes that your client will agree the revised terms of the NDA, which we understand were recently issued by Pinsent Masons directly to your client. The signing of the NDA will allow fuller discussions to take place, which will hopefully assist your client in becoming better informed about the issues the airport faces. The discussions will also allow the airport to share the terms it is proposing to resolve the current disagreement between the parties. All of these steps are being proposed with a view to the airport hoping to be able to remove its objection and to avoid the time and costs for both parties in participating in the aviation session of the public inquiry. We would therefore encourage your client to respond to the revised NDA and to then, upon release of the draft wind farm mitigation agreement, be willing to meet with the airport. There is no reason why these steps cannot take place promptly, and it would be in the interest of both parties to do so before the end of August 2021, given the timetable in the public inquiry. We look forward to hearing from you once you've had an opportunity to take instructions.
So, how did the airport respond to the offer in the letter from CMS to Denton's, which is APP 2-9?
Yes, well, we clearly made an offer to meet with them to discuss the terms and to share the terms.
Thank you very much, Ms. Kilpatrick. I've got no further questions.
Thank you, Mr. Brown, and thank you, Ms. Kilpatrick. Mr. Hardy, did you want to speak?
I just have, yes, just one point of clarification. There was something raised in re-examination in answer to a question from Mr. Brown, and that was the potential to have to spend a further amount of money on the terma. And I just want to be clear that sum was already dealt with in the answer that there was a £2 million surplus. And we can see that in the agreed transcript of the evidence at Clauchrie on page 13. So I wonder whether it's just worth just going back to that. So it's Mrs. Kilpatrick's evidence from the Clauchrie inquiry.
If you just give me the reference or the page number,
it's page 13, and it's halfway down page 13, and it's in the middle. So Mr. McLeod says, by my calculation, if you add the figures up, 4.4, 1.3, 1.6, 0.735, I think we get to 8.2 million that you'd receive by 31st of March 2020, and then that's correct. So looking at the costs, you'd have incurred cost of a commissioning term of £3.2 million surplus. No, because like I say, we'll be making a further investment in terma in order to extend the range to the range we have from the current radar. So that isn't the limited extent of the investment. Well, what's the cost of the extension? I can't tell you the exact figure, but it's going to be probably 750,000, maybe more than that. And then Mr. McLeod's quite generous. He says, okay, well, for the ease of rounding, let's call it £1 million. So by the time you've spent another £1 million on extending the radar, you still have 2.2 million in the bank from wind farm mitigation. So the point being that 2.2 surplus is after the element of extension to terma that Miss Kilpatrick just raised in her re-examination. It's just to make that point clear.
So I've got the reference,
yes.
so I shall look at that. Mr. Brown, would you like to respond?
Yes, so if Mr. Hardy's saying that's an inconsistent statement, I think it has to be put to Miss Kilpatrick.
Well, I'm very happy to do that, yeah. I mean, I'd put the question that Miss Kilpatrick said that her evidence at Clauchrie was correct. She didn't want to change anything. That is a very clear answer exchange with Mr. McLeod, and I'm happy to just go on that. And unless Miss Kilpatrick wants to change her evidence from Clauchrie and change her evidence she's given to me, I don't see the need to recall her.
Well, Mr. Brown, I don't want to prejudice your position, so I will leave it to you to decide whether or not you would wish Mr. Hardy to put that to Miss Kilpatrick.
Yeah, I'm very happy to.
I would wish that to be put to Miss Kilpatrick.
Okay, let's do that.
Okay. Miss Kilpatrick, are you still there?
I'm just going back on.
So I'm grateful, Miss Kilpatrick. If I may then, you agreed the Clauchrie evidence was correct?
Yes, it is, yeah.
Page 13. I'm right in saying, aren't I, that when those questions were put by Mr. Cloud, he talked about the £3.2 million surplus. You then came back with the same answer that you've just given to Mr. Brown. Well, you need to spend a bit more. You spend £1 million. The 2.2 is net of that expenditure. That's right, isn't it?
No, that was one of the. If you look at my precognition, there are various elements that we need to invest in to bring the performance of the radar back to its current standard. One is the range extension, which is what I spoke to Mr. McLeod about. I think I need to find my precognition here, but the second one was that I've just mentioned then was the dual channel. I didn't mention that to Mr. McLeod as far as I'm aware. And then I've just talked about the PSR feed as well.
The dual channel, that's new. It's not anywhere else. It's the first time that's been heard, I think, in the last question of this 5-day inquiry. Where's that cost? Where have you costed that up in your table of costs and risks?
I said quite clearly then that we've not gone to tender on that.
You haven't, right? Very good. I don't need to take that further. Thank you.
Mr. Brown, do you have any final questions in terms of re-examination on that point specifically?
I don't, thank you, sir.
Thank you. Okay, well, thank you again, Ms. Kilpatrick. Thank you, Mr. Brown. That brings us to the conclusion of inquiry session 1 in this inquiry. So we shall resume, as I said, so it's a week on Monday the 18th of October, and that will be specifically for the landscape and visual inquiry session 2. The hearing session in relation, obviously, where we will be amongst many other matters, we'll be considering the conditions proposed in relation to this aviation matter. That's in hearing session 2, which will be on Friday, the 22nd of October. So I shall see you then. And Mr. Brown, are you joining us for the hearing session?
Yes, sir. I shall
Yes.
be there.
Okay, so I shall see you then. Thank you for your time and your contributions so far. Have a restful weekend, and I'll see you a week on Monday. Thank
Thank
you.
you very much. Thank you, sir. Bye-bye.
Thank you, sir.